Hello everyone, this is Dhanashri Chougale and you're watching Ganga Education. Welcome back to my channel. On this channel, you will get information regarding law and competitive examination related to law. So subscribe my channel and hit on a bell icon so that you can get information regarding upcoming videos. So stay tuned. This is part 3 of Civil Judge Junior Division Judicial Magistrate of First Class Preliminary Examination held in 2012. In first two parts we have discussed question number 1 to question number 50, and in this part we will discuss question number 51 to question number 75. So let's get started. Now question number 51. Person in occupation of premises is tenant if option number 1, he is only permitted to use that property. Option number 2, he is put in exclusive possession of it and pays rent. Option number 3, such person had lived for few days with the deceased original tenant as his friend. And option number 4, all of the above. And the correct answer is option number 2, he is put in exclusive possession of it and pays rent. Now question number 52. A landlord shall not be entitled to recover the possession so long as the tenant, option number 1, does not get other premises. Option number 2, keeps the premises good. Option number 3, is ready and willing to pay rent. Option number 4, pays rent and permits increases and observe the terms and condition of tenancy. And the correct answer is option number 4, pays rent and permit increases and observes the terms and condition of tenancy. Now question number 53. A tenant cannot be evicted even if he erects a permanent structure. Option number 1, if landlord does not raise any objection. Option number 2, if tenant obtain permission of corporation. Option number 3, if such construction was necessary for safety of the building. And option number 4, if landlord consents to it in writing. And the correct answer is option number 4, if landlord consents to it in writing. Now question number 54. Premises let to banks or public sector undertaking having paid up share capital of rupees dash 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 are exempted from protection of Maharashtra Rent Control Act 1999. Option number 1, 2 crores. Option number 2, 1 crore. Option number 3, 3 crore. And option number 4, 5 crores. And the correct answer is option number 2, that is 1 crore. Now question number 55. No decree can be passed against the tenant for the requirement of premises for landlord unless option number 1, the tenant has acquired possession of other premises. Option number 2, the tenant has capacity to purchase other premises. Option number 3, the tenant admits the plaintiff's claim in the suit. Option number 4, landlord bona fide claims it and is likely to suffer greater hardship. And the correct answer is option number 4, that a landlord bona fide claims it and is likely to suffer greater hardship. Now question number 56. A landlord can get possession of premises for its demolition and construction of new building only if option number 1, landlord has sufficient funds with him for it. Option number 2, if he has approved plan and estimates. Option number 3, landlord undertakes to provide new premises equal in carpet area of the existing one. And option number 4, all of the above. And the correct answer is option number 4, all of the above. Now question number 57. A proceedings to recover possession of premises from licensee is to be filed in option number 1, Court of Small Causes in Mumbai and elsewhere the Civil Court Junior Division. Option number 2, City Civil Court or elsewhere the Civil Court Senior Division. Option number 3, the court of competent authority appointed by the state government under the MRC Act, that is Maharashtra Rent Control Act. And option number 4, none of the above. And the correct answer is option number 3, the court of competent authority appointed by the state government under the Maharashtra Rent Control Act. Now question number 58. If a landlord withholds any essential supply or service to the tenanted premises, the tenant can seek remedy by way of option number 1, suit in small causes or civil court. Option number 2, application to the competent authority appointed by the government. Option number 3, application for restoration in the small cause or civil court. Option number 4, writ petition in the Honorable High Court. And the correct answer is option number 3, application for restoration in the small cause or civil court. Now question number 59, whether appeal against the decision in appeal of appellate bench of small causes court or district court would lie before option number 1, Honorable High Court. Option number 2, competent authority appointed by the state. Option number 3, no appeal lies. Option number 4, Supreme Court. And the correct answer is option number 3, that no appeal lies. Question number 60. If the landlord fails to keep the premises in good and tenantable repairs, the proper remedy for tenant is option number 1, to file a suit. Option number 2, to make an application to the court. Option number 3, to make such repairs himself after 15 days notice to the landlord. And option number 4, to file a writ petition. And the correct answer is option number 3, to make such repairs himself after 15 days notice to landlord. Question number 61. If sufficient cause is made out, the time for filing proceeding in the court can be extended if option number 1, the delay is for presenting the appeal or application under Civil Procedure Code. Option number 2, the delay is for filing suit. Option number 3, the delay is for filing any original proceedings. And option number 4, all of the above. And the correct answer is option number 1, that is the delay is for presenting an appeal or application under Civil Procedure Code. Now question number 62. If the cause of action for suit arises when the plaintiff is minor, he may institute the suit. Option number 1, within the period prescribed by limitation for such suit after he attains majority. Option number 2, within 1 year of his attaining majority. Option number 3, within the time prescribed by limitation from the date of cause of action. And option number 4, none of the above. And the correct answer is option number 1, within the period prescribed by limitation for such suit after he attains majority. Now question number 63. In computing the period of limitation for any suit, appeal or application, the day from which such period is to be reckoned, option number 1, shall be excluded. Option number 2, shall be included. Option number 3, may be excluded by the court in an appropriate case. Option number 4, none of the above. And the correct answer is option number 1, that is shall be excluded. Now question number 64. While computing period of limitation of suit, time spent in another similar proceedings in the court having no jurisdiction can be excluded if option number 1, the plaintiff had acted in good faith with due diligence. Option number 2, the plaintiff was misled by the wrong advice. Option number 3, the plaintiff bona fide found the place where he filed such proceedings more suitable to him. And option number 4, none of the above. And the correct answer is option number 1, the plaintiff had acted in good faith with due diligence. Now question number 65. A suit can be said to be in limitation even after period prescribed. Option number 1, if the parties to the suit by agreement had agreed to waive it. Option number 2, if the defendant admits the whole claim of the plaintiff in notice reply. Option number 3, if the defendant acknowledges liability of the plaintiff's right before expiration of the period of the limitation. Option number 4, if the defendant does not raise any objection to the plaintiff's claim on the ground of limitation. And the correct answer is option number 3, that is, if the defendant acknowledges the liability of the plaintiff's right before expiration of the period of limitation. Now question number 66. When a new defendant is added in the suit shall be deemed to have been instituted against him from option number 1, the date of his addition. Option number 2, the date of institution of suit. Option number 3, the date on which issues are framed. Option number 4, the date on which summons is served on him. And the correct answer is option number 1, that is the date of his addition. Now question number 67. In case of an easement by prescription, the period of 20 years must be ending within dash 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 from the date of institution of the suit. Option number 1, 3 years. Option number 2, 2 years. Option number 3, 12 years. And option number 4, 1 year. And the correct answer is option number 2, that is 2 years. Now question number 68. Suit on a bill of exchange or promissory note payable at a fixed time should be filed within 3 years from option number 1, the date of execution. Option number 2, the date on which time expires. Option number 3, the date of demand. And option number 4, the date of denial to pay. And the correct answer is option number 2, that is the date on which time expires. Now question number 69. A suit for possession of immovable property based on title can be brought within 12 years from option number 1, the date of dispossession. Option number 2, the date of demand of possession. Option number 3, the date on which the defendant refuses to deliver possession. And option number 4, the date on which possession of defendant becomes adverse. And the correct answer is option number 4, that is the date on which possession of the defendant becomes adverse. Now question number 70. Where no period of limitation is prescribed for an application, it can be filed within option number 1, 1 year. Option number 2, 2 years. Option number 3, 3 years. And option number 4, 12 years. And the correct answer is option number 3, that is 3 years. Now question number 71. An ordinance can be issued by the President at the time when option number 1, the Parliament is in session. Option number 2, Lok Sabha is not in session. Option number 3, Rajya Sabha is not in session. Option number 4, both the houses of Parliament are not in session. And the correct answer is option number 4, that both the houses of Parliament are not in session. Now question number 72. The proposal to prefer charge against the President of India should be moved by at least dash 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 of the total number of members of the House. Option number 1, 1/10. Option number 2, 1/5. Option number 3, 2/3. Option number 4, 1/4. And the correct answer is option number 4, that is 1/4. Now question number 73. Article 14 of the Indian Constitution does not prohibit option number 1, class legislation. Option number 2, special treatment to an individual. Option number 3, treating unequal at an equal footing. Option number 4, reasonable classification. And the correct answer is option number 4, reasonable classification. Now question number 74. Under Article 356, a proclamation to remain operative must be approved within 2 months by option number 1, Lok Sabha only. Option number 2, Rajya Sabha only. Option number 3, both the houses of parliament. Option number 4, either one or two. And the correct answer is option number 3, both the houses of parliament. Now question number 75. Who presides over the meeting of Lok Sabha in the absence of the speaker? Option number 1, the president. Option number 2, the vice president. Option number 3, deputy speaker. And option number 4, prime minister. And the correct answer is option number 3, that is deputy speaker. That's it for this video. You will get link of first 2 videos in description box. Please go through it and stay tuned. Thank you for listening.